Honor, practicing attorney for over 25 years, and the reason they call it the practice of law because every day you're learning better ways to practice and honing your skills. Some questions that were submitted to me that I'd like to answer and share with everyone because I think they would be of benefit. Great questions. Pitfalls to look for when deciding whether or not to take a case. First of all, I believe that clients deserve an attorney who is committed to the cause and will give the blood, sweat, and tears that it requires to see the case through. So really, one of the first things is do you, as the attorney, have that connection with the client? Is this a cause that you want to take up? Is it a case that you believe in? One that you're not going to dread working on? Because whether you as disciplined as you can be, we all have the tendency to work on the cases that we want to as opposed to the cases that we need to. So that's kind of rule number one, gut check. Is this a client that you want to work on? Is this a case that you are comfortable and competent to work on? How do you look for things when you're talking to them on the phone before even scheduling the first consultation? Things I look for are expectations, their level of anxiety and or emotions connected there too. It's understandable people are going to be anxious when faced with a legal problem, and that's why a lot of times you have to politely cut them off because people don't know how to ask lawyers questions, and we as lawyers need to know, who the parties are to do a conflict check, where it occurred, and to make sure that it's a jurisdiction that we're licensed in, what the cause of action is, so that we can make sure it's something that we're competent in. The who, what, when, and where details can be important, and people tend to, when they're anxious, just kind of ramble on. The other thing that I personally look for, I don't like replacing other lawyers in a case. I'm not so egotistical to think that I'm the best lawyer in the world, and the complaints that they're going to have against their previous lawyer, whether valid or not, they may have against me, whether valid or not, and I don't want to buy trouble. I would prefer working for people that are going to be pleased with my work, and I do everything that I can do to make sure that that happens. I work very hard to make sure that my clients are happy because that's what makes my practice successful, and that's what makes me satisfied as an attorney. Do I normally get a signed fee agreement at the beginning of the case? Absolutely. If you're going to engage in a case or take on work that you're charging a fee for, you need to get a signed fee agreement. Now, if it's a case where you're not sure of, I think it's completely legitimate and upfront to be able to tell a client, you know what, I need to think about this. And if you have that gut instinct, then you should tell the client that. I'm going to sleep on it. In fact, on a big case, you should tell the client to sleep on it. What I tell clients is if you don't feel a sense of relief when you walk out the door, that is a weight lifted off your shoulders, then I'm not the client. I'm not the lawyer for you. And the same goes from the lawyer's perspective. There are times, we have to be very cognizant of the fact that it is a privilege to practice law, but there are also business aspects to it. Without the fees coming in, the lights don't stay on. However, our ethical duty is to try to screen that business interest away as much as we can because our duty is first and foremost to the client, and the business part of it has to be secondary. And really, if you focus on doing best for the clients, your business is going to be fine because you'll get more clients and you do good work. What is an appropriate amount of time to determine if a case is a winner or loser? Well, it's difficult to determine that. I mean, every case, even the best facts sometimes aren't winners, but more on point to the question is appropriate amount of time. That's dependent on the level of research and the time commitment involved in that, and then also the time constraints perhaps on the client. I would say within a week or so as a general rule of thumb. I would definitely want to take long enough that I could do the adequate research and also give myself time to really ponder things. There was a judge who once said he was surprised in fee disputes that lawyers didn't bill for basically time thinking about a case. We bill for about everything else, a phone call, a fax, and an email, but there isn't the time sort of pondering the case. And really that's what you need to do. Sometimes you have to take time to, sit down and really go through what the strategy is going to be, outline what the facts of the cases are, and how you're going to align the witnesses. There's a lot of percolating, so to speak, that you have to do in a case that's necessary to be successful. And while I'm on this point, your bills on a case should read like a good chronologist. Just think a chronology of the case. And really, if you print out your bills, someone else in the law firm or a layperson should be able to tell exactly what you did in the case. Because just think about it. If you got a bill, for 5 hours of research, the client's instinct is, hey, this lawyer should probably know this stuff. But if you explain it that you're looking for a case that is on point, that will persuade the judge that the merits of your case are such that you should prevail, that's much more a much more clean way to describe that. And I think if you write it in a very direct and lay kind of point of view and explain what you're doing, it helps not only the client understand what they're paying for, but also it gives a good chronology. So if someone else, whether it's on a fee dispute or someone else who's working at your firm, like, hey, what did Matt do on this case? Well, yeah, last time looks like he did A, B, C, and D. It's very easy to tell what the next steps will be and what needs to be done on the case. Do you charge interest on unpaid invoices? Yes, I do, but I'm not very good at math. So, and I think it gets tricky in terms of charging interest on it. That is, it is allowed, and be sure to check, of course, always with your local bar. And of course, nothing I say in here is intended to be legal advice to you. It's just for general public information. But if you are going to charge interest on your invoices, first you must put it in the fee agreement, and second, it must be exactly correct. So make sure that you have a mechanism for charging invoices. But I think definitely a late fee is appropriate, and I think clients should be apprised of that up front. And the best way to do that is to send them regular bills. I try to do bills every 2 weeks, but I also, when I do a lot of work on a case, I may send a bill just to let the client know, number one, that I've been working on the case a lot, probably with their knowledge, but also to let them know that how the process works. I send a bill early in the case to sort of let them know what I bill for and the types of things, because otherwise people may not understand that, yes, in fact, I do bill for the time that they call and ask me questions about the case, because a lawyer's time is his stock and trade. So my time answering questions is vital to the preparation of their case, their understanding of it, and they need to understand how that process works early on, so they're not surprised, if they have 5 phone calls and they get billed for them, that they're upset that they got billed for the 5 phone calls. And also I try to be very efficient in managing communication, and sometimes that requires that you sort of screen that if it's in a non-emergency situation, to help the client, sort of prevent the client from running up their bill inadvertently. I think the best way to do that is, like, I'll often tell clients to group their questions. I know you have questions and you need answers, but one of the things you can do is say, you know what, write them down, and when you have 5 or 6 questions, that you can either call me, we can set up a phone conference, because phone tag is really difficult with lawyers, whether you're a lawyer trying to reach another lawyer or you're a client. I may be in court, well, I am in court a lot. So if you call me at 9 o'clock tomorrow morning, I'm going to be in court. I may not be able to get back to you till 10 o'clock. And then I try you back, and it just goes on and on. So I use a system that allows the client to message me, and then we set up a time where we have a phone conference, which means exactly that. I'm going to call that client at 3 o'clock. That time is dedicated to them, and there's no phone tag involved, and they can be prepared for the conversation as well, as opposed to getting caught while they're coming out of a Burger King. Let's see what else. Do I send a canned email, or do I call the client first? That is, when rejecting a case. Really, that depends on the amount of time that I spent with the clients or the expectations. I probably do both. I would want to be able to call the client and say, listen, and looking at this is maybe just not the type of case that I'm able to handle right now based on my caseload, or I'm not comfortable with the facts of the case. But you give them the 4 out of 5 dentists. There's another lawyer that may be interested, and you want to encourage them to pursue their action. Make sure, if you have spent some time on it, they're aware of the statute of limitations. And certainly, if it is a contingency fee case or a case where involving a statute of limitations, and you have been involved in it to the point where you have researched the statute of limitations, you have an ethical duty to apprise the client of that statute of limitations, and then the only way to decline the case then would be to send a certified letter, return receipt requested, so that you can show that you've let them know that. Referrals from other attorneys. I think referrals are sort of the life. My main source of clients are former clients. So again, that doing the right thing for a client, doing your best for a client is probably the best thing to do for your business. But you have to keep your business aside. Because if you're thinking about your business, you're not thinking about your client, which should always come first. That's the best way to build your business. Other attorneys is a great way to build a referral network, and they'll hear back. Again, if you do good work, those attorneys are going to feel confident. I can tell you that I'm very picky on who I refer cases to, because when I refer a case to another attorney, to an extent, in reality, my reputation is on the line, because if they have a bad experience with that other attorney, then that impacts me negatively, and I don't want that to happen. I want people to be able to trust that when I say you can go talk to this person, they've got experience in this type of case and they're good at it, then I'll feel comfortable doing that. And oftentimes it helps to I say, listen, would you let me know how it went? I'd love to hear your comments afterwards, if that was a positive referral. But again, I'm very picky about that kind of thing. Do I think referral services are worth the money? Yeah, I think referral services that are run by bar associations are a very good process. It allows the public to seek different attorneys who have an emphasis in different areas. There's so many opportunities through marketing now to sign up for different companies that do that. But the problem then is you're competing against 5 other lawyers. And then you get into, I'm not a price shopper or a price cutter. I always tell people I'm not the most expensive attorney. I'm not the cheapest attorney, but I do try to deliver steak at, reasonably gourmet hamburger prices, is basically how that works. And there is a modicum of, you do get what you pay for. I don't run a high volume business, and therefore my hourly rate's a little bit higher than the maybe person who does run a high volume business. So those are the questions that were submitted. Excellent questions. Actually, a couple more. I want to finish these up because there's really good questions. Do I keep hard copies of files for each client? The answer to that is, at the conclusion of a case, I give the client their entire paper file, and I obtain from them a client receipt. Otherwise, like in Missouri, the rule used to be 10 years. That means I have to keep all of their paper for 10 years. Now it's 8 years. So if I give them their entire paper file and then sign the client receipt, they can keep that. I don't have to store it. But I do keep the trust log and things of that nature. And I also keep an entire scan file as a backup in case something comes up later. I think it's probably more beneficial to have a digital copy, but I think the rules of professional conduct require you in your state to keep it for a certain number of years, and in Missouri that happens to be 8 years. How do you handle the amount of fees you charge for a plea, trial, or otherwise? I charge by the hour, whether it's a plea or for trial. I get enough up front so that it can cover my fees, so that I can at least get through a substantial part of the case, whether it's plea or trial, without having to request additional fees. And there's nothing better than being able to finish a case and do your best and give a client that check back from the trust account and say, hey, I didn't use all the fees, here's your refund. It doesn't happen often. Lawyers, unfortunately, sometimes don't always do that, but I think clients who get that check back at the end are pleasantly surprised. And again, that's a way you can change people's opinions about lawyers, by the things you do in that particular case. I also will kind of set expectations as a reasonable estimate. It may cost this, but you have to be careful, because some cases at the outset may look like they're going to be A, B, and C, but things arise that cause them to be much more complicated or take more time. I've had a couple of those in the recent history where, because of one reason or another, things took longer, not because of anything myself or my client did, because of things we had to do strategically in order to obtain the result that the client needed, and it took longer and the fees were higher. And in those circumstances, I think it's reasonable also as a lawyer to consider discounting the fees, because there were circumstances that were beyond your control and not due to the client's circumstances that caused the fees to be higher, and I think people should be given a fair shake when they can. What else? Let's see. How much of a fee can be non-refundable? That depends on the rules of ethics for your state. I think generally probably the best answer is to say that the amount of fee that's non-refundable is really what would be lost because you took the case and can't take another case in terms of a conflict. And last, when speculating the amount of work for a case, do you make it clear that the advance fee only covers work up to a certain amount? Absolutely. And the way you do it is explain your billing process and maybe even show them a bill and say at the outset, I'm going to send you a bill. It's going to say, A, B, and C, and then show them how you enter time and what you keep track of and what is or is not billable, and then tell them, I do what's called an evergreen retainer. So that means if it gets below a certain level, they have to refresh it. The best way to explain it is, first of all, we don't call it a retainer anymore. We call it an advance fee deposit because that's what it really is. And the best way to explain that is to tell them that it's like a checking account where you put, or a savings account. You're going to put X number of dollars in there. And when I have earned it, the invoice will draw against that. So if it's $10,000 and I've done $2,000 worth of work, you've still got an $8,000 credit. And when it gets below a certain level, the fee agreement requires it to be refreshed or brought back up to that level. And that's just to make sure that, as you get toward the end of the case, you're not thinking about the fees, you're thinking about making sure the case is finished out. And again, nothing better than being able to give a client a check at the end of the case and saying, hey, we didn't use all the fees, here's your money back, and glad we had a successful conclusion to your case. So hope that answers all the questions. It's been helpful. I'm Matt O'Connor, practicing attorney for going on 25 years. Remember, this is not legal advice. It's just intended to be some advice. I encourage you to always research the rules of professional conduct in your state and to look for advisory opinions where necessary to avoid any legal pitfalls. Thank you very much.